This video will talk about the I751 waiver, the waiver from filing jointly an application to remove the conditions of the 2-year green card. So typically, after a person has a green card for 2 years, they have to file a petition to remove the conditions. Typically, they should file it jointly if they're still married, but in many cases, people get divorced before the end of the 2 years, and then they have to file a petition to remove the conditions by themselves, and this is called a waiver. So in this video, we'll talk about this particular waiver, but more specifically, what happens when somebody files this waiver and they get an intent to deny their conditional green card. This is happening a lot right now. So watch this video, and I'll talk to you about what to do when you get such an intent and how to overcome it. I'll see you on the other side. In this video, we'll talk about I751 waiver, the waiver of the joint filing to remove the 2-year conditional green card. We'll talk about what happens when you file this waiver and you get an intent to terminate your conditional status, just like here, an actual intent. We'll go through this intent because they're very similar, and they're sending a lot of these intents right now, and we're getting a lot of questions, and I wanted to make a video specifically on that. Before that, if you're here for the first time, make sure to subscribe to our channel, click that bell to be notified as I release videos every single week, and also give us that big like so YouTube will be able to show this video to more people just like you. My name is Jacob, and I'm an immigration attorney located in San Diego, California, and we represent clients in all 50 states, and we're excited to talk about this 751 waiver topic because it's really important. So the waivers are based on section 216C4. This section essentially states what the hardship is based on. It's based on the fact that it was a bona fide marriage, but it just didn't work out. It was no fault of the parties. And the second waiver that can be done is based on abuse. There's an abuse in the relationship. The abuse immigrant can file a waiver based on abuse using form I-751, right? So typically those, those intent to deny, they go through the general description of what happened in the case. They state that section, just like we showed you right here, and then they go to state as to what information the couple provided. In this case, they provided, there's a long list of things they provided, like joint bills and accounts and all that kind of stuff. So typically those intents, they will list what already was provided. As you can see, it is really important to provide as much evidence as possible to show that the marriage was bona fide and assets were commingled and things like that. Then the intent states a very specific section of the Code of Federal Regulations, 8 CFR 216(5)(e)(2). And let me read you that section. In considering whether an alien entered into a qualifying marriage in good faith, the director should consider evidence relating to the amount of commitment by both parties to the marital relationship. Such evidence may include A. Documentation relating to the degree to which financial assets and liability of the parties were combined. Again, it's really important to know that it is very crucial when you file a waiver to show that you actually had assets that were commingled, that you combined assets. Number 2, documentation concerning the length of time during which the parties cohabitated after the marriage and after the alien obtained permanent residence. So remember, once you get your conditional green card, they want to see that the couple continue to live together. There are so many cases that I've seen that people got their conditional green card and then they stop living together. That's not good, and that's one thing that is an important factor to the success of that waiver. And number 3, birth certificates of children born to the marriage, of course very helpful, but it's not necessary. And finally, other evidence deemed pertinent by the director, which means it can be anything that you can show that this was a real and bona fide marriage. So once again, in this case, they will list all the evidence that was given, personal declarations. They will go through what was in those declarations. In this case, they will actually quote sections of the declarations to show that the couple were in a good relationship. In this case, they had short duration residence, and they will quote that what happens before what happens when they got the green card, the conditional green card, what happened after the conditional green card. The officer in this case was able to show that after they got the green card, the couple did not live together for a long time afterwards, and they actually listed those addresses, so kind of they go in length. That's why it's such a long decision. They're going back and showing that the evidence from the family, the letters from the family were not sufficient. So for example, when you submit tax returns, they want to make sure that it's real evidence. In this case, this couple provided tax returns, but there was no evidence they filed them with the IRS. So for example, if you provide evidence that you submitted anything with the government, make sure you actually do it. In this case, the couple did not file their taxes with the IRS, and the immigration caught it. So that was not good. And that hurt their credibility before the USCIS. Also, a lot of the evidence that this particular person provided, in this case, the immigrant is filing by himself, was conflicting from evidence that was already provided before to the USCIS. And therefore, the USCIS is going to give little weight to that evidence. So it's really important that if you're providing any evidence in your case, specifically if you do it on your own, essentially that you're no longer married, you're now divorced, that evidence is not going to give enough weight if it's contradictory to what you already given them, either in the first interview or in previous filings. In this case, they already filed jointly, they were denied, and then the immigrant filed the petition alone. So there was a lot of inconsistency, and immigration didn't give him credit for that inconsistency as well. Once again, don't forget, if you are here for the first time, you enjoyed this video, make sure you subscribe to this video, click that bell to be notified. Also give us that big like so YouTube can show this video to more people. And finally, we have a big Facebook group with a lot of people that are going through the same process as you are. If you want to be part of our community, join that Facebook group. The link is in the description of this video. So once again, thanks a lot, and I'll see you in our next video.